Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers beach attire, excessive force, and hindering, and comes to us from Samantha Panda's channel. Be sure to check out the description below and give them the credit that they deserve. On August 2nd, 2020, Myrtle Beach Police Department officers Zach Reffy and Kyle Dick detained professional aerialist Samantha Panda and her sister-in-law Kendall Lee during an outing to Myrtle Beach after an unidentified woman called to complain about their bathing suits. Ms. Panda's boyfriend, who was at the beach with Ms. Panda and Ms. Lee, began filming the encounter after Ms. Panda was placed in handcuffs.
So, why is it illegal to have a bikini on the beach?
I literally wear this to the beach every day.
I want us to show you. We're going to show you.
Absolutely. Did someone complain?
Yeah.
I mean, we don't just show up and tell everybody we just don't show up and throw people in handcuffs.
I understand.
Turn right to it. Nudity, display specific, nominal parks, specific sexual areas prohibited. Shall be unlawful for any person appearing in the nude on any public beach access in the public waters or any public property in the view of the public.
I'm not
So
nude.
nobody's nude. There's nobody nude right now.
I'm not nude.
Okay, you're in a thong.
Thong is not nude. All right.
The officers refer Ms. Panda to Section 5-30 of the City of Myrtle Beach Code of Ordinances, which prohibits public nudity, and we will discuss this code in more detail later in this episode. Public nudity regulations are common in the United States, and almost every state has some sort of law involving lewd behavior or indecent exposure. Public nudity is also often regulated even more strictly on the municipal level, as is the case in Myrtle Beach, and these local ordinances have generally survived constitutional scrutiny when challenged in court. In the 2000 case of Erie versus Paps AM, the U.S. Supreme Court upheld a public indecency ordinance in the city of Erie, Pennsylvania, that prohibited knowingly or intentionally appearing in public in a, quote, state of nudity. A nude erotic dancing establishment called Candyland challenged the constitutionality of the law, arguing that because the ordinance required the dancers to wear a certain amount of clothing, it violated their First Amendment right to freedom of expression. In reaching its decision, the court determined that while, quote, being in a state of nudity is not an inherently expressive condition, nude dancing is expressive conduct that falls, quote, only within the outer ambit of the First Amendment's protection. Despite the First Amendment implications, the court upheld the ordinance as a content-neutral regulation that attempted to avoid the negative secondary effects associated with nude dancing establishments, rather than restrict speech. In other court cases, public nudity ordinances that prohibit women, but not men, from exposing their breasts have been challenged as a violation of the Equal Protection Clause of the Constitution. While the majority of courts considering these cases have upheld such laws, in the 2019 case of Free the Nipple Fort Collins versus City of Fort Collins, the 10th Circuit Court of Appeals upheld a district court's determination that such an ordinance, quote, discriminates against women based on the generalized notion that, regardless of a woman's intent, the exposure of her breasts in public is necessarily a sexualized act. Thus, it perpetrates a stereotype ingrained in our society that female breasts are primarily objects of sexual desire, whereas male breasts are not. Based on this reasoning, the court concluded that there was a strong likelihood that the plaintiffs could establish that ordinance violates the Equal Protection Clause. The U.S. Supreme Court has yet to weigh in on the issue, but on January 13, 2020, the court rejected a request to review the 2019 case of State versus Lilly, where the Supreme Court of New Hampshire upheld an ordinance banning women from appearing topless in public. As mentioned before, we will discuss the parameters of the Myrtle Beach Municipal Code in a moment, but it is important to note that the concept of public nudity is still a relatively controversial subject within the courtroom.
As long as it's not in a sexually explicit manner, and there's nothing sexually explicit about this.
I just read it.
Okay, nude, in the nude. This is not considered nudity. There is clothing covering their private parts. Just because she has a bikini that is more revealing does not mean that she's in the wrong.
Nothing in there says thong. Any quote-unquote private parts are not uncovered. None of our private parts are uncovered. You literally detained me for being in a thong.
Yes, because of the way you're acting. So, what's going on?
Can he get off of me, please?
Well, he's holding so that way you don't fall.
I'm not going to fall.
What's going on?
Dave Cohen told us that we're nude and that we can't be nude on the beach. I'm not nude. I asked him to show me where it says like he wear a thong. He said no. He told me that he wouldn't show me, and I said, okay, then we're done here. And then he put me in cuffs immediately. And then after that, they brought me over here, showed me their book, which doesn't say anything about being in a thong. It just says you can't be nude.
Jimmy Jam?
Jimmy Jam, yeah. So, I am not nude. Everything that is a quote-unquote private part is covered. You can't tell me I can't wear a thong.
With the exposure of anatomical parts, like what she has on stuff that she's not doing, that you can't have.
But you can't tell us that. Anatomical parts could be my belly button.
Listen,
You can't just make things up at your
not,
discretion.
Listen, I'm not making. I'm telling you what the city ordinance is. Anatomical. I'm not just saying, hey, anatomical parts. That's what the city ordinance is. So let me go pull up the city ordinance for it. Give me just a minute. I'll get everything figured out. I will show it to you. But you cannot be out here with a thong. You have to have on a cover. It's actually $101 off the gate. How's that going?
You said no. You said you didn't want to talk to me.
She asked you to show you. She asked you to show you, and then you guys said no right off the bat. So she did say walk away after that.
Ms. Panda admits that she attempted to walk away from the officers when they initially approached her about her swimsuit, and the officers claimed that her behavior is why they elected to place her in handcuffs. While it is difficult to conclude anything definitively without footage of this encounter, it's likely that the officers were attempting to legally detain her to investigate a potential violation of Myrtle Beach's public nudity ordinance. Although officers are permitted to use handcuffs when detaining a suspect who is deemed a flight risk or a potential danger, the unnecessary use of handcuffs can give rise to excessive force claims against police officers. In the 1989 case of Graham versus Connor, the U.S. Supreme Court held that when an excessive force claim arises in the context of an arrest or investigatory stop of a free citizen, it should be analyzed under the protections of the Fourth Amendment, which guarantees citizens the right to be secure in their persons against unreasonable seizures of the person. Under the Fourth Amendment standard, the force used must be reasonable under the circumstances from the officer's point of view at the time the force was used. In explaining this standard, the court stated that, quote, the calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. If Ms. Panda were to file an excessive force claim against the officers for placing her in handcuffs, a court would apply the standard outlined in the Graham decision and, quote, determine whether the officers' actions are objectively reasonable in light of the facts and circumstances confronting them, without regard to their underlying intent or motivation. As mentioned before, it is difficult to conclude whether Officer Dick's use of handcuffs were warranted without seeing footage of the initial encounter. But if Ms. Panda did attempt to walk away from the officers after being detained, then there is a high probability that a court would find her handcuffing to be justified.
You want to come around and throw your weight around like I have to do everything you say. That's not the case. So if you don't want to show me something, you don't want to tell me what you're going to detain me for.
I did tell you.
No, you didn't.
I did.
So you can just make up whatever you want.
It's not made up.
It is made up because it's saying nudity. There's no nudity.
You keep chiming in, you're going to jail.
For what?
For talking?
Hindering.
Hindering what?
Officer Dick threatens to arrest Miss Panda's boyfriend for quote-unquote hindering, which is likely a reference to Section 14-63 of the City of Myrtle Beach Code of Ordinances. The ordinance states that, quote, while a law enforcement officer is actively in the lawful discharge of his duties relating to law enforcement, investigation, or arrest, it shall be unlawful for any person to place or position oneself in such proximity to the law enforcement officer that would have the effect to physically impede, interfere, obstruct, hinder, or molest the law enforcement officer in the performance of the public duty. Given that the code requires an individual to physically hinder the officer to be found guilty of this offense, it is highly unlikely that a court would conclude that Ms. Panda's boyfriend violated this ordinance by merely talking to the officer.
Walk away.
We have our social distance. We have our social
I'm
distance.
dealing with them. I'm investigating them right now, not you.
Okay, and I'm with them.
You're still talking.
What the? So, like I'm so same outfit
Hey,
so many times.
Just invoke the fifth right now. That's it. There's no need to talk and to speak with them. They're being irrational, unreasonable, and that's just how it is.
Alright, specify anatomical parts. Male, female, genitalia, public hair, buttocks, anus, bone, all this other stuff. That's what the thong's coming up. Like I said, it's the original ordinance of the 530. And you can look this up on your phone too. It's not any secret school stuff.
Officer Hinton shows Ms. Panda and Ms. Lee the public nudity ordinances that they are accused of violating. Section 5-30 of the City of Myrtle Beach Code of Ordinances states that, quote, "It shall be unlawful for any person to intentionally appear on any public beach, beach access, in the public waters, any other public property, or in view of the public in such a state of dress or undress so as to expose to the view of others specified anatomical areas." Section 5-1 of the Code of Ordinances clarifies that the phrase specified anatomical areas includes buttocks and nipples. Officer Hinton argued that Ms. Panda's bathing suit bottom exposed her buttocks, and that Ms. Lee's shirt exposed her chest because it was see-through. While the City of Myrtle Beach's website states that, quote, "Thong-style bathing suits are not allowed on the beach or in public," neither the ordinances nor the website provides any guidance as to what constitutes such a bathing suit among the many variations of thong-type bathing suits, or what is an acceptable amount of visible anatomical area under the local ordinance. Ms. Panda and Ms. Lee attempted to gain some clarity on appropriate beach attire from the officers, but they did not provide any substantive guidance on the matter. Given the language of these laws, it's likely that a judge would agree with the officers that both Ms. Panda's bathing suit bottom and Ms. Lee's shirt violated the public nudity ordinances by exposing buttocks and female breasts at or below the areola to the public through their state of dress.
This isn't nudity.
So
And I'm not saying you're nude. It's the fact that you're out here in a thong. That's why we have to have a thong ordinance. We have to cover up. Two, if you're out here in a bathing suit and a cover up, you have a thong under it. That's fine.
So what's considered a thong? Because that's a Brazilian cut bikini.
We're not getting
I-
Brazilian
Because, well, it does matter. Because if
No.
I'm going to go buy a bikini, I would like to know if I can wear it.
But our ordinance just says buttocks. That's all. It says.
So
Okay,
that's
so then that's a buttocks over there. So
And
that's what.
okay.
Yeah, was it? Okay, so can we leave now? Okay,
Yeah,
great.
okay.
Thank you.
After discussing the public nudity ordinances, the officers allow Ms. Panda and Ms. Lee to leave without further incident. Ms. Panda posted the interaction on her Facebook page, Instagram, and YouTube, writing on her Instagram post, quote, "I will not allow women to feel like they are obligated to dress a certain way because it makes someone else feel more comfortable. This is a vulgar use of force, an egregious overuse of power, and it needs to be addressed." In an interview with WPDE Myrtle Beach, Ms. Panda pledged to take action, stating that while she wants to get the ordinance thrown out entirely, if the law is going to stay on the books, she believes it needs to be easier for people to understand and for police to enforce. Ms. Panda said in the interview that she was in the early stages of forming a legal team, but it is unclear whether she filed a complaint about the incident or what type of legal action she plans to pursue, and it does not appear any lawsuits have been filed thus far. However, a few weeks after Ms. Panda's encounter with the officers, on August 21st, 2020, a South Carolina woman named Nirvan Ibrahim and her teenage daughter filed an excessive force lawsuit against the Myrtle Beach Police Department for another incident involving Officer Reffi and Officer Dick. The complaint alleges that the officers unnecessarily handcuffed the women and held them at gunpoint during a traffic stop that occurred when the women were driving a rental car with a license plate that had previously been reported as stolen. As of the date of this episode, the case is still pending in the Horry County Court of Common Pleas. Overall, Officer Dick and Officer Reffi get a C-, because although they were likely within their authority to detain and investigate Ms. Panda and Ms. Lee, the officers made no effort to de-escalate the situation, maintained a rude and condescending demeanor throughout the interaction, and baselessly threatened to arrest Ms. Panda's boyfriend. Regardless of whether the language of Myrtle Beach's nudity code exactly described the type of bathing suits Ms. Panda and Ms. Lee were wearing, the officers would likely have been within their authority to investigate them under the suspicion of violating Section 5-30. As mentioned in many episodes of ATA, corroborating the evidence offered by a 911 caller typically can serve as reasonable suspicion for an investigative stop. And once the officers received the call and located two individuals that matched the description offered by the caller, the foundation for reasonable suspicion was built. The officers also made the decision to contact a superior officer, which significantly contributed to the peaceful resolution of the interaction. All that said, the officers utterly failed to de-escalate the encounter, and much of their language was accusatory and tone-deaf. They also threatened to arrest Ms. Panda's boyfriend for verbally criticizing their actions, but ultimately did not act on those threats. Much of the Myrtle Beach officers' conduct was within the bounds of their authority, but their lack of professionalism and poor discretion disparaged the legitimacy of their investigation. Ms. Panda and Ms. Lee get a B. Because although it is likely that they were lawfully detained, the two remained calm and collected throughout the encounter, had the awareness to begin recording, and posed legitimate verbal challenges to the officers without becoming overtly hostile. While it is likely that Ms. Panda and Ms. Lee were in violation of Section 5-30, they did not challenge the existence of the code, but more so the code's verbiage and constitutionality. Ms. Panda's two principal points were that 1. What she is wearing does not fit the language of the code, and 2. The code should not grant officers the authority to dictate what kind of swimwear a person can wear, within reason. Both of these points are valid, and when taken at face value, Section 5-30 does appear to raise some questions of constitutionality. However, the constituents of a municipality are free to participate in the drafting of local laws, and codes such as this one typically reflect the majority opinion of any given community. The fact that the police were called on Ms. Panda and Ms. Lee is likely a testament to the overall consensus of the local citizens regarding the code, and there is a strong possibility that Section 5-30 would have been challenged long ago if the citizens of Myrtle Beach found it to be unconstitutional or misaligned with their community values. Much like many other aspects of life, the law can be seen as a relative concept that should be interpreted and enforced based on the societal standards of the locality it governs. And although a majority of Americans would likely disagree with Myrtle Beach's enforcement of proper swimming attire, the citizens of Myrtle Beach are more than capable of participating in their local political process and dictating the code and conduct of their community. Let us know if there's an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out the ATA Patreon page for more police interaction content.